Fitzgerald and Parole for
Yes, Mr. Rule.
May it please my lords and my lady, the representation is as follows: for the appellant, myself and Mr. Bedford, who takes his place having had some difficulties on the train, and for the respondent parole board, my only friends Mr. Cohen and Miss Jackson appear. I hope that the court has received a small supplemental bundle, which was as late, I think, as Monday night. It puts together some correspondence and some documents that have been toing and froing between the parties in recent times. If the court hasn't seen it, there are some hard copies here which I can hand up.
This is the one called the second supplemental bundle.
It is indeed.
I have it, I think. Yes, I have it.
I'm grateful. There are hard copies if that's of any assistance to the court, but and they've been paginated. I think the original electronic one maybe didn't have the pagination, but in any event, if the court is familiar with that documentation, in short, I've had the opportunity to discuss it with Mr. Cohen. The position is that there was a late respondent's notice and late response to that by way of the information in this bundle, which essentially gives the court the full information about what the level of legal aid expenditure would be compared to the level of damages award, and the financial circumstances of the appellant, much as they might have been assumed or presumed. They're there in black and white, and ultimately, if we're right for the appellant that there needs to be some proportionality exercise, and there hasn't been, it may give the court information which it otherwise wouldn't have, and may therefore be a factor as whether or not to remit the matter for that assessment, or whether the court has sufficient information itself.
Okay, so we have two applications which I think relate to what you're talking about.
Indeed.
And we've discussed it already, and what we'd like to do is just proceed on the Bene SA. We'll deal with them round.
Indeed, and there's no demur from that approach from the bar. We're both. I'm grateful.
And just before you leave the supplementary bundles, you said that there was information in them. I looked quickly at this, but could you just summarise for us what the essential information was about the scale of costs in the case, if that's what you're referring to?
Yes, certainly. Just let me go to my note. I was going to deal with it later in any event, but I can immediately deal with that. Yeah, I'm grateful. The statement deals with it in paragraph 9. I have
page.
Page 10, my lord. So page 9.
Sorry, I'm obviously in the wrong button. Thank you. 9. Thank you.
So page 9, paragraph 9, the legal aid bill at the time of the trial below, the hearing below, was £17,693. That's calculated at legal aid rates, not the inter-partes schedule, which was obviously dealt with in the usual way at that time. So that is the figure on which the statutory charge would bite, or any recoupment from the damages would bite. So essentially almost approaching double what the damages sum is.
And the figure in paragraph 3 above relates to what different?
The current expenditure on legal aid rates is within the 39,100 certificate.
So
that includes the appeal costs as well.
What does saying a cost scope of 39,100 mean?
It means without exactitude about exactly how much all of the expenditures are to today, they should be within 39,100, because the scope was extended on the basis of estimates, which have to be essentially met. If there's overrun, then the lawyers take that.
So is it right to understand that as being a cost ceiling?
Yes.
That was imposed, and so the actual expenditure, if you've given the 17,000 figure, which was a trial, and then there will be, of course, unfortunately, an appeal figure.
Indeed.
Which you will be able to give us in due course, so that we have the full picture.
My lord, the only hesitation I have is that the actual crunching of numbers occurs when all the times come in as of today, essentially. Yes. So they may not yet have been collated. In broad terms, they will be within 39,100. Will be the appeal costs added to the trial costs. So the total figure will be within 39,100 and close to it, I'd imagine, because the the reason for that figure being there is that's the expected
So,
expenditure.
of course, for the moment, the exact figures don't matter, but your presentation is that the total expended at the trial and for the appeal now leaves very little headroom with the 39,000 figure.
Indeed, yes.
Thank you.
So essentially on the legal aid costs, to trial it is about almost double. Now it would be 4 times the amount of the damages. That goes to what the statutory charge figure would apply to. Obviously inter partes costs are calculated on a different scale. They're not limited to the legal aid rates, but those are the figures for that purpose. The other figures which the evidence provides include the financial circumstances of Mr. Fitzgerald, both whilst a serving prisoner and upon release. And essentially it comes to this, that he had within the prison system, he would receive a small amount of money for working within the prison, but he has an account which is set out where the spends account had a savings account of £93 balance. The spends account had £360 odd in it. On release, he went on to benefits. He wasn't in employment, and he receives universal credit in the sum of £368, which goes in on the 10th of November. So that's 3 days after the release. And the bank account demonstrates also some of the grant they receive when they leave the prison for subsistence is in cash, and he pays some of that into the account. Some small sums of £30 are paid in. But the account balance began at £4 something. So essentially not a man of means, beyond the assumption one would make being eligible for legal aid. He didn't have to contribute to his legal aid, didn't have any of the levels of income which caused contribution. And for him, therefore, the sum of £10,000 is a very significant sum by comparison to his financial situation. So if I may return to the nature of the appeal and the way in which I invite the court to approach it. The core circumstances which relate to this matter are that the appellant succeeded in the claim below and received judgment in his favour. That's the starting point, which puts us into the realms of the general rule and general expectation that a successful party recovers the costs of vindicating their rights through the court. The specific violations the court knows is of the rights concerning liberty, one of the more fundamental of human rights, as is often said, and in particular Article 5.4 concerned with delay to liberty, so the prolongation of detention, the loss of liberty in that period. And that type of breach of Article 5.4 is distinguished in the authorities from procedural fairness failures in terms of consequences. The need for damages arises specifically and most often, not exclusively, but most often, in relation to delay cases rather than procedural errors. So the type of 5.4 breach is that of being the victim of the unlawful act of delaying, which caused, as a matter of probability, the prolongation of detention in his case. Therefore, the sum of damages calculated by that scale rather than a lower scale for anxiety and distress only. So there is an element that compensation is calculated by virtue of an element of loss of liberty. The relief that is provided is just satisfaction, provided under Section 8 of the Human Rights Act in the domestic scheme, and using the term just satisfaction to reflect Article 41 of the Convention and how the Strasbourg Court calculates and provides for damages in just satisfaction in redress for the consequences of the violation. As we'll come to, it also uses that provision in relation to costs awards as well. So Article 41 covering both the damages element, as we would domestically call it, compensatory element, and also the costs. The learned judge below, as we know, awarded a sum of £10,000. That is neither appealed nor cross-appealed. That is the sum that is warranted on the authorities for the loss of liberty in this particular circumstance. And then fundamental, of course, to this case is the consequence of non-recovery of costs inter partes, is that the entirety, as we just established from the figures, the entirety of the just satisfaction, the redress the state gives for having breached your right to liberty, is lost, deprived of him, and paid to another organ of the state, the legal aid agency, who lent him the money to bring the claim. And a fundamental point that is a platform to this case is to make this point in rebuttal, really, of how the case is put against me by the respondent. And it is this claim is concerned with the right to recover in exactly the same way if you're privately funded or if you're funded by legal aid. The point is about the damages not being lost when you've succeeded in your claim and none of the other established reasons to reduce your costs of recovery exist. So success without the partiality or the unreasonableness that might cause, in the amount of cost, for example, that might cause deductions to be made on all the usual principles, and there's no challenge to any of that. What we're concerned with is someone who would otherwise be entitled to their costs being deprived of them on the basis that the identity of the defendant who breached the rights is the parole board and not, for example, the Secretary of State. And it's on that sole basis that a rule has been perceived to have developed or has developed. We'll have a look carefully in due course, if we may, at the Davies case and what precisely it says. But the perception, certainly at present, is that the Davies rule or the Goulet rule would be that there is no recovery of costs against the parole board in judicial review proceedings. We submit that that is an oversimplification of what courts have previously said and not correct in that respect, but also must be reconsidered in light of the Article 6 points, in particular the jurisprudence that has developed, which has yet to be considered by this court in relation to this matter.
Could you at some stage, not necessarily now, but just consider whether another question to ask is not just about the consequences of non-recovery, but what the consequences of recovery would have been, so that you can explain to us what would have happened if you had received an order for some or all of your costs, and what the consequences would have been for the client in those circumstances.
Yes. I perceive my Lord's question is the practicality of the financial situation as opposed to the reasons why there might be a rule at all, etc., which I'll come to.
This is before we get anywhere near Davies.
Yeah.
Is contemplating your client as being either legally aided or your client as being a privately paying person. What would the consequences for him have been had his application for costs succeeded in part or in whole? What sort of scenarios then arise? Could we have that on the horizon at some point when we're considering these?
I can deal with that now, my Lord, if that's convenient. The starting point would be the order is made that there be recovery of costs. The order would provide either indemnity or the standard scale. Let's assume the standard scale. I don't think this was a case in which there were application of indemnity costs, etc., or that type of scenario. So standard process. The standard award of costs is the reasonable sum of costs is awarded to recover, and that is the standard principle that I referred to earlier, that costs are taxed according to reasonableness.
So you'd have asked, you'd have come with a schedule of costs. You'd have asked for 17,500.
No, we'd have asked for the inter partes rate, so the costs would be much higher because under legal aid scheme, the lawyers are limited to a capped rate.
Right. So you'd have asked for some multiply of 17,500. Let's say, just for the sake of argument, it's more than double that you'd ask for.
Well, there must be a number.
There is a cost schedule, and it is, I think, more than double. Yes, it is that type of that is the type of comparison between legal aid rates and private reasonable rates.
Well, you can offer some other figure, but let's suppose you stood up at that point with a private client, and you said, well, we've spent 40,000 on this. Right. So take the matter forward from there? What happens next?
So the judge has made the order that you'll recover on a reasonable recovery basis. The parties will then negotiate typically, and there'll be an offer put forward by the defendant. This is the typical scenario. There's no obligation that they make any offer. But prior to going to a cost judge for an assessment of what the reasonableness is, either it's accepted that the figure is reasonable, or the defendant will counter offer and suggest a figure that they consider to be reasonable,
Yes.
making any points they wish to that they might
Negotiation.
make to a cost judge. If the matter settles
Yes.
in advance of going to a cost judge, which is generally the position,
Yeah.
not of course in every case, but most often, the parties will over time come to together. There will be a deduction, let's say, take 10%, 15% of the total.
Right, so let's suppose it comes either as a result of the cost judge or as a result of the settlement, it comes to 35,000.
Indeed.
Something
That
of
is-
that sort. Now,
indeed.
you're,
That is
the-
then
the-
paid by the parole board to the claimant through his lawyers.
yes, but their fees are 40,000.
Yes. So
Right.
that sum goes to the lawyers, and that is then all the legal aid money is paid back. The lawyers, if they've been paid out by the legal agency in advance, there's typically payments at
Well,
stages.
we were at the moment in the world of a private client.
Yes.
Right.
So
I'm thinking, and I want you to put me right, I'm thinking that then leaves 5,000, which is a shortfall, or not. That means that the fees have been reduced,
yes.
or that actually they're entitled to the 40,000.
I can only speak from my experience. I don't know any solicitor who's insisted on the unreasonable portion of their fees from their client in these cases. So typically, if you haven't got your full inter partes schedule, or let's say private rates schedule, if you haven't got full recovery, you're not going to take that from your client's damages if you've agreed that.
In principle, you can, and there are lots and lots of cases in civil justice in general in which that is exactly what happens. I'm not doubting your experience in the specific sort of case we're talking about, but in principle, clients all the time will be chased by the solicitors or by the lawyers for the gap between what has been assessed and what the actual costs were. You know that.
Yes, my lord, that's not my experience of legal aid cases
I don't doubt
because you're recovering more than you would have been paid if you'd lost.
But
So-
the point of my lord's question is we weren't talking just about legal aid, we're just trying to understand what the
I
principles
understand
are.
that. The vast majority of these cases will be legally aided because they're serving prisoners. But however, I accept all these points, but all these points don't go to this point, which is what the court is interested in, which is that the reason you're not recovering full costs, and if they were to buy any damages, is because the costs were unreasonable. That's a simple principle, not under issue in this case. So the deduction is you shouldn't have allowed your lawyers. Let's say it's private. You shouldn't have allowed your lawyers to charge those fees. They were unreasonable. You decided to go with a very expensive.
Okay, can I put to you, Mr. Rule, that I understand the point you're making about reasonable and unreasonable, but in principle, if a client, let's say they were a multinational corporation, just dealing with principles, and they have incurred with their legal team fees of, for the sake of it doesn't matter, £40,000, it doesn't make any difference. The cost assessment, whether by agreement or through a process, comes out at less than 40,000, say 35,000. The gap, the £5,000, is something which the law firm will expect to recover from their client. They're entitled to, whether they do in practice. I completely agree with you about the practice in the context of legal aid, but in principle, that debt is still a debt.
Yes, but this is all standard rules about why you don't recover because the unreasonableness. And the point I'm making about it's your fault you allowed your lawyers to charge unreasonable fees and you agreed them, subject to going to the legal ombudsman. That is the reason why there's a deduction. There's not a deduction because the defendant you've sued happens to be a public body that is the parole board. So it's a different basis. I'm not taking issue with the basis on which, if the costs are unreasonable, that you may have a deduction, and in a private client scenario, the kind my lord's talking about in a commercial context, without a human rights issue perhaps, there is a shortfall, you are liable for that because you chose to have unreasonable costs. But that's a long way, as the court knows, from what we're talking about.
Just to complete the point is that debt would, in principle, be capable of coming out of your damages.
Yes, but my lord, that's not challenged by this case. It doesn't arise on this case, to be fair.
Okay.
So what arises on this case is there is no reason in the established system for controlling reasonable costs for deduction of your damages. The reason you're not getting any damages is simply a perception that there's a rule you can't have them, despite being the successful claimant. So that's where this case challenges it, and it does so in a human rights context. And I can't stretch out of that because it's the human rights violation that's the fundamental underpinning of Article 6 and Article 5 false engagement. So we have to come back to the circumstances of this case on practicalities are, whatever happens with the reasonableness of costs is a separate issue. In the practicalities of legal aid, there's always greater recovery at inter partes rates than there would have been.
You're discussing this quite high level. Before leaving this point and allowing you to go on, could I just move into the field where we are in legal aid and you have a situation where you largely succeeded before the judge. So we move away from our private client and we have a client whose legal aid costs are 17,500. And the judge says, well, I think you should have your costs, but subject to a reduction of, let us say, 20% because of this element in the case. So you get 80% of your costs. What then happens?
But that we have examples of, but that's what happened to Mr. Faulkner. He brought proceedings.
Well, without going around the houses, I'm presuming that the gap, which is 3,000 or something of that sort, comes out of your damages.
Yes.
Right. Well, there's not unanimity in the court apparently, but I thought that that it wasn't just a question of you having got zero in this case, and consequently your entire damages being at risk from the legal aid charge. It sounds as if anything other than full recovery of costs was going to lead to that outcome. And even then, what happens? Let's suppose, I mean, if you got an order for full costs, 17,500, then your damages are immune. The charge doesn't bite. But if you only got, let's say, 15,000, then that would begin to eat into your damages.
Yes, again, we're ignoring the uplift to inter partes rates, which is in practical terms a big difference, because at 80% inter partes, we're still likely to be way beyond the legal aid limit. And that means the lawyers still, in my experience, universally, would not be asking the client to lose their damages to fund the lawyer's extra bit.
Yeah, but that's in a sense a grace and favour situation,
indeed,
which is no doubt very proper. But
it is. But my lord, the principle is not one I object to. If you have taken bad points, if you've exaggerated a case, if you're being deducted for any of the reasons that the court will deduct from 100% recovery, that is the consequence of the process of litigation you've taken, the way in which you present your case. And that's why I mentioned Mr. Faulkner's case, because he lost his damages as a result of having taken a cross appeal which failed to increase his damages, lost the appeal to reduce his damages, and as a result, the recovery of costs was by the other parties, the state parties, against him because of the conduct of the litigation. Now we go back to first principles. If you're not fully successful, you may not recover your full cost. Understand that.
What I'm understanding is that unless you get 100% of your costs when you're legally aided, you're always going to be at risk of the charge.
Yes.
Thank you.
Yes. So, my lord, just to be absolutely clear, I take no attack on the principle that the courts can lawfully, provided they're acting proportionately and consider the matter in the round, can apply deductions for unreasonableness of level or for unreasonable conduct in the litigation which causes costs. So additional costs from unsuccessful issues, etc. That's not something I challenge. So those, to be fair, are not, in my submission, incompatible with properly and proportionately, in the right case, considering the human rights issues, considering the cost recovery points that we do advance. So those can be consistently and compatibly still part of the process. I don't challenge those. So can I just go back to where I was in relation to why I say it doesn't matter whether we're legally aided or private. The point of principle is equally applicable. And it comes to this, which is important, as I say, because of the way the respondent presents its case. The effect of the legal aid funding is a loan rather than an outright grant. And the importance of that, and you can see that from the case law, the Davies and Lilly and Company case, and also from the statutory charge manual, both of which we have in the bundle, and I can take the court to those if that helps. But both of them come to this, that the legal aid is a loan of costs, which is recovered where you recover your costs inter partes, so you then repay anything the legal aid agency has paid you and keep the remainder of the inter partes costs, or property or damages are made available to repay a first charge that the legal aid agency takes over anything recovered by the proceedings. And it's the latter which applies in this situation to Mr. Fitzgerald, because he hasn't had the IP cost recovery order, leaving the shortfall on the loan, but there is the charge available over the damages secured by the proceedings. And that is what is then taken. And could I just invite the court to see what Sir John Donaldson, Master of the Rolls, said in the Davies and Eli case about legal aid funding, because it just makes this point very clear. It's in our authorities bundle, tab 19, please. It begins on page 174, but if the court goes over to 177, and this was a case where there were multiple claimants, 1,500 or so, 1,000 or so were legally aided. Test cases were being selected, and there were issues related to how costs would be apportioned, etc., with the test cases. What on the point of principle about legal aid being a loan, this is where it becomes the relevant dictum on page 177. The court has that there. I'm afraid it's not numbered. The fourth paragraph down, towards the end of it, last sentence or two, and ultimate. Unfortunately, it betrays a woeful misunderstanding of how the legal aid scheme works. This is a point of general importance, and the basis of the scheme deserves to be better known. Does the court have me? Put simply, but for present purposes, wholly accurately, legal aid helps those who lose cases, not those who win them. Legal aid makes out-and-out grants to those who lose cases. It only makes loans to those who win them. And then he explains the way it works in an example. Go to the last paragraph. But suppose the plaintiff wins, as the legal aid fund claims he does more often than not, a very different picture emerges. As a successful party, it doesn't have to pay the defendant's costs. Usually the defendant orders to pay his. But don't celebrate too soon, and we get into the possibility that you have excessive fees or you don't recover your fees. It will come out of your damages because you're successful. The loan is still there. It's not a grant, it's a loan. And if one goes over the page, the second paragraph, in other words, for the successful plaintiff, the legal aid fund provides a loan, not a grant, at least to the extent his damages are sufficient to repay the loan. Put slightly differently, every legally aided claimant should realise if he succeeds in recovering more by way of damages, costs and interest than its cost to recover them, the money actually paid out exceeds his own, after all what he expects, he'll be in no better position than an unassisted litigant. So it puts you into the same position the private client would be. You recover your costs, to the extent you can recover your costs on the usual principles, you then have the repayment of the loan, but you keep the damages. And I mentioned the statutory charge manual. That's tab 14. It might be just to finish off this point if I show the court that as well. Tab 14, page 137 onwards of the authorities. At page 139, 2.1, what is the statutory charge? 1A. Referring to the dicta we've just looked at, the legal aid statutory charge manual as of July 2024, it is designed to put a legally aided party in the same, as far as possible, in the same position as successful non-legally aided persons. And it refers to it as the loan rather than the grant, etc. So for that reason, it's clear that there's no difference in the circumstances of which Mr. Fitzgerald complains, a successful claimant not receiving the inter partes costs and then being liable to pay those costs themselves applies whether you have a statutory charge loan or whether you owed your money to your solicitors under the private paying agreement. And again, matters not whether you've paid them in advance or whether you're owing them in arrears and they have some lien or whatever. But the reality is, in either case, the position is supposed to be identical under the scheme. The other point that was raised about legal aid by the respondent, if I can deal with that at the outset, is also one which doesn't have any bearing on this particular case. The suggestion has been made that there may be a process in which some claimants can have a waiver of a statutory charge. So the legal aid person might be in a better position than the privately paid person if the legal aid director were to waive the statutory charge. It doesn't arise on this case. It isn't, for a number of reasons, it just cannot arise. Firstly, because the Lord Chancellor would have to have been satisfied at the time he first granted that it was a test case chosen amongst others. This can be seen from both the regulations and the authorities on this point. The first of those, let's start with the regulations perhaps, at tab 8 please. This is the Civil Legal Aid Statutory Charge Regulations beginning on page 66, and I'm going through to regulations 8 and 9. They're on page 71 and 72. Eight doesn't apply. Regulation 8 is the wider power, which concerns where it causes grave hardship or distress. It doesn't apply because that's only for when the statutory charge is for the solicitor, not the legal aid director. It applies essentially to some family cases. If you go back to, I think it's regulation 4. Those which are, if you look at regulation 7, the statutory charge is usually in favour of the Lord Chancellor, except for the regulation 4.3, family, or no certificate issued, etc. So legal aid director has the charge, no one else, and for him, the waiver is set regulation 9 over the page. And the Lord Chancellor may do so, if he considers it equitable, waive all part, if the following conditions are satisfied. A, the director was satisfied, and the was is deliberate. Was satisfied in determining that a legally aided party qualified for legal representation, that the proceedings had a significant wider public interest, and in making the determination took into account there were other claimants or potential claimants who might benefit from the proceedings. It refers to the regulations that describe significant wider public interest. Now again, we have the benefit of judicial analysis of this, and it comes to the point I've already made. If you're not a test case being selected at the outset, you don't qualify for the waiver. You cannot come within regulation 9. So the suggestion made against this claimant is that by happenstance he's legally aided rather than private paying client, that he should find someone else to forego the costs rather than the defendant public body pay the costs, having violated his rights, doesn't have any purchase. It simply cannot arise on this case. And that can be seen again from the case of Faulkner and the director of legal aid agency, but I won't come to that at the moment, if I may. So I make those points at the outset to differentiate or distinguish the idea that there's something special about legal aid other than the general principle of recovery of costs. There isn't. This case is actually about the recovery of costs in a human rights violation case where the public authority happens to be the parole board. So it's by way of preliminary points, it's plain that the judge below considered himself bound to follow Court of Appeal authority on this, the Davies and the Gourlay cases, to the extent that there is, following what Lord Reid says about costs and practice rather than precedent, to the extent that itself is correct. Of course, it doesn't apply to this court, which isn't entitled to consider these points and is doing so, in fact, for the first time. The key issues, of course, concerning Article 5.4 and Article 6, and it's a fundamental proposition that if the individual is denied the proper redress before the national courts, he remains a victim of the violation. That has been held to apply where the amount of damages provided was inadequate. See, for example, Betteridge in the UK and the Scordino case. Scordino we have in the bundle. Those concerning 5.4 breaches. Betteridge concerning 5.4 breaches. And my final point before moving on to the grounds is on the parole board's case, essentially it creates a grave difficulty, which is not one that can be countenanced, which is this. In order to enforce your right to a speedy hearing, to determine your liberty, and compel the Article 5.4 provision, a litigant is entitled to come to the administrative court and seek relief. That court has provided mandatory orders. It provides quashing orders where there is something in the decision making that's standing as an impediment. But it also can and does, as in this case, provide relief for what has been happening up until that point. So the litigant has an ongoing breach and complains both of the ongoing breach to try and bring it to an end as soon as possible, but also seeks the damages for what has happened thus far. Obviously, we don't want to have a position where separate proceedings have to be taken over the same period of delay, same issue. And it has been dealt with in very many cases before the administrative court that following the ending of the unlawful delay period, the damages element has been capable of being settled. It wasn't settled in this case, but in a large number of others in which I've acted, that has been possible to do. But it depends, in this case, we'll come later in the grounds to the issues over unreasonableness of failing to accept the offers that have been made, which include, as the judge didn't appreciate below, offers which did not have any figure of damages, but damages to be agreed, but at least had the liability concession offered, refused by the parole board. But if the parole board is right, that in circumstances such as these, having successfully obtained £10,000 of damages required, necessary as just satisfaction for the loss of liberty occasioned by the Article 5.4 breach, you cannot have your damages because you brought a judicial review rather than waited until the end. Don't try and enforce your rights. Don't try and have the primary relief, which is an end to the violation, but you must wait for your secondary relief, which is compensation where we failed to stop it.
Actually, in the present case, the judicial review proceedings were issued. Then, after some while, Ms. Fitzgerald was released, and so by the time the matter then came on for determination, the only issue that remained was damages.
Indeed.
Right, but
well, liability and damages.
Liability and damages. But you say, no doubt, that whether the court had been called upon to make a mandatory order or not is not relevant. It was a claim which was correctly issued seeking a mandatory order, but it just happened that he had been released by the time the matter came before the court.
Indeed, indeed. And there cannot be a position where the litigant brings the proceedings properly because he's still experiencing the violation. That violation ends during the course of proceedings, but the parole board says we're not going to pay any of your costs in bringing proceedings, despite the fact we have no defence.
I'm sorry, it's so obvious, I'm sure, to everybody else, but it's the point is that the fact that the court was not called upon to make a mandatory order for the matter to be considered is just because that's what happened, because he'd in fact got a hearing by the time the matter came on in that way.
Correct.
So, I mean, I see the force in the point you're making. To does it work the other way round? And I completely understand the point you make that it was your client was right and entitled to bring the proceedings he did in those circumstances, and the fact that it's that he'd be released by the time the matter came on can't make it better from Respondent's point of view. But what if he did in fact bring a separate claim afterwards? Do you say different principles would apply then? I would imagine you'd say no.
Well, my submission is there shouldn't be any differentiation between you're in the admin court having damages for an Article 5.4 civil Section 7 breach, or you're in the county court having the same.
Right.
You should recover your costs as a successful party. The Parole Board, I think, has a policy which we'll come to. It's only in the supplemental bundle, so the court may not have seen it, but that policy seems to indicate an acceptance. They'll pay costs if you've issued county court proceedings, but they refuse if you've issued judicial review. Now that might be oversimplifying it. I might stand to be corrected, but essentially there cannot be any principled basis as to why in one situation you recover your costs and in another you don't. And so I think that's really the point that I'm making at the outset, is that the difficulty with that suggestion is it does create this problem, which the Supreme Court, Lord Reid again in the Jordan's case, the Northern Irish inquest delay Article 2 case, made the point you cannot have a situation where you're compelling claimants to wait until after the end of it and then bring the claim, rather than being able to try and enforce the right at the time, even if there's a damages element, as there was in those cases.
I get that, and I do understand the force of the point you're making, but can I just plant the seed of a thought in you for you something to think about, not now necessarily at all, but maybe sometime. On that footing, if it is the same principles to be applied, irrespective of how it happens to happen, and therefore, for example, if it had been a claim brought in a county court, then you might need to think about what the costs orders would have been made if it had been made in the county court.
Well,
So I'm not saying you have. I'm not asking you to deal with it now, Mr. Rule. I'm just saying that it struck me from the. As I keep saying, because I do see the point you're making, you need to just take into account that, of course, if it was in the county court, then the county court cost rules would apply, and that's not necessarily the same thing as what you're asking us to do.
Well, my lord, at the point of allocation, there would be consideration to all of these points. At the point of allocation, the claimants in these cases would invite the court to list it for the multi-track because of the nature of the violation, the nature of the matter, etc. So there wouldn't be a substantial difference in that respect. But
if you get it allocated to the multi-track, there might be.
Yeah, I understand the point. And of course, then unreasonable behaviour issues apply as exceptions in fast track and small claims. But ultimately, this case is concerned with the costs that are reasonably incurred in bringing proceedings, which include an element of seeking at the relevant time the mandatory relief, etc. So there is that difference in that level of cost will be different because you have had to go through the admin court process with permission, with etc. So there is that practical difference. But I understand my lord's point that if you're in civil proceedings, there are cost rules that apply, but that shouldn't necessarily be a tail wagging a dog, as it were, in case we get to the position of that comparison. What is important is the principle of recovery of your costs, where the court is entitled to do that, shouldn't be limited by a practice of the court, which deprives you of the substance of your violations redress. So, my lords, my lady, if I may, the grounds I suspect are set out adequately, clearly at bundle page 17 to 20, and it won't help me to go through them seriatim now. I lump them together slightly as I go through the submissions that I make, and I'll indicate that. A starting point may be to look at the decision of Lord Reid in the Gourlay case, Gourlay and the Parole Board. He made a number of points about matters of practice, and also to some extent deals with the question of rationale for the Davies approach. And part of my submissions will ask the court to focus carefully on what is the rationale or what is the justification for any such rule, and the absence, we say, of that justification having any bite where you're talking about a claim of this nature, of an Article 5.4 delay violation, and the findings that the learned judge made below as to when that, what that was, that administrative delay, what actually happened, and what your complaint succeeds on. So that's our tab 42, Supreme Court, Law.
Is there a particular reason you're going to
Sorry,
Goulet
43.
before Davies? Is it in order to emphasise the breadth of our abilities?
Not only for that point, my lord. If that point can be taken as read, I can focus on what it said about Davies. But yes, I do intend to go to Davies itself, but I thought it was helpful to see what Lord Reid had said about it as well. I could go in either order if the court feels it's more
No,
useful.
I just wanted to understand what your theory was, as it were, in doing this.
So I will take as read then, if I may, the fact that developing cost principles is a matter of practice rather than strict precedent, etc., as Lordship made clear. And the practice to be reviewed where there's sufficient reason to change so, etc., etc. Obviously, in this case, to consider for the first time the human rights arguments that aren't part of the decision making in Goulet and Davies. But if I go then to paragraph 44 of Lord Reid's speech on page 861, and it was tab 43, just to correct what I said earlier. What is said about the reason for refusing the award in that case? Third line in particular, Judge had identified the point of central importance as being that the board had taken the decision under challenge while acting in a judicial or quasi-judicial capacity, not made itself an active part of the litigation, consequently fell within the scope of the practice described in Davies. So it's relevant to note that that was a decision taken while acting in a judicial or quasi-judicial capacity. And this is important if I highlight the point that will be made, because the rationale for independence of judiciary or for non-involvement in a partisan way of a lower court in proceedings, those apply on the basis that there's been a judicial decision rather than dealing with the question of whether or not a public authority such as the board is liable for a violation of Article 5.4 by having failed to provide the hearing.
Would you mind just taking us briefly to the facts of Goulet so we can situate this
So it was
remark?
yes. If you'll accept an oral explanation of it, Goulet brought proceedings against the Parole Board challenging a decision that it had taken, which denied him release and refused to recommend him for open conditions. He failed in relation to the direction for release. He succeeded in relation to the open transfer challenge and sought costs in relation to that successful judicial review. There were no damages issues involved, but there was a quashing of the board's decision, and he sought his costs of those proceedings, judicial review proceedings, challenging the board's decision.
Right, so it was a partial success.
Partial success, but I think to be fair, I don't think that's part of what the ratio is. I think what is under challenge is, can I have my cost because I won, rather than can I not because it's the Parole Board. So the issue was very firmly about judicial function, judicial decision making, and it didn't involve a breach of Article 5.4 and damages for delay issue. There's a different type of challenge is the point really I make in terms of what it can or cannot tell us in terms of this case. Looking for the principle behind the rule that there wouldn't be recovery, we see reference to a decision acting in a judicial or quasi-judicial capacity. The quasi-judicial one can almost ignore now. The Supreme Court has been very clear in a case called Pierce 2 years ago. The Parole Board is to be treated as a court essentially, and even though we're talking about cost principles, I don't think anyone's taking issue with its description simply as a court of an inferior nature or tribunal. Lord Reid then continues with the rationale for it at 46. Differentiating a body which takes a decision in a judicial or quasi-judicial capacity and then declines to defend it, but, and this is just below letter B, choosing instead to maintain its impartiality and to let the reasons which it gave for its decision speak for themselves. Acting in accordance with principles of judicial independence and impartiality. And one can understand that principle or that concern being applicable to a judicial order, a decision. Of course, it cannot have any bearing on a public authority that's failed to provide a hearing that's in breach of Article 5.4. There's no question of impartiality or independence there. You're obliged under the statute to provide an Article 5.4 compliant hearing. You haven't done within the speedy timescale that's required. And on the authorities, that's a particular type of violation which requires damages to be paid.
Mr. Rule, I'm not doubting at all that it's a particular kind of violation which requires damages under Article 5. Why is it not necessarily also a judicial act? It may not be one in which the decision maker chose to maintain impartiality afterwards. That's a different question in my mind. But at the moment, I'm just telling you, it's not immediately obvious to me that it's not a judicial act.
My Lord, my submission on that is it's not important to give it nomenclature or description in that way. The question is whether it bites. Is it the type of, if it's a judicial act, is it the type of judicial act which requires for independence and impartiality reasons to be immune from costs and for its reasons to speak for itself in the way that Lord Reid is discussing here? So the answer, obviously, in the different type of case of which Mr. Fitzgerald's is there's no concern over independence or impartiality. There's no reasons speaking for themselves to allow you to sit back and allow the superior court to review the inferior court's decision making. That's the differential. So when one's looking for the justification or the rationale for why have a special rule or special principle practice applied to the parole board, it can't extend beyond, or doesn't in my submission extend beyond, the points that are being made here, that it exists for independence of the judiciary so that you don't have a partisan parole board in the proceedings, but that doesn't
in that case, as in this, the parole board had been found to have acted unlawfully.
Indeed. That's obviously essential for the upholding of either the public law or the private law damages claim. Not for both, but for either of those to succeed, there'd have to be some unlawfulness. But my point, my lord, is focused on what was the object of the unlawfulness. If it's a judicial decision, then one has to balance. And this is not a carte blanche either. We'll come to Davies. Doesn't say you can always never have your cost. But what it does say is that that's a concern. One of the reasons, or the reason it exists, is to ensure there is this judicial independence, impartiality upheld. Let the reasons speak for themselves.
Right, I'm just looking at the head note of this. This is page 843. So as you described for us the context and the quashing of the decision in relation to the transfer, finding the parole board had acted unlawfully. The judge had made, at E, the judge had made no order for costs, finding that it had been acting at least quasi-judicial capacity throughout under no exceptional circumstances. The claimant appealed from the Court of Appeal's dismissal of that appeal, contending the established practice as to cost orders against courts and tribunals should no longer be applied, since amongst other things it created an exception to the general rule. And then we find, just by letter F, most unusual typo in the weekly law reports. It's a collector's item. So anyhow, there was a lot of the same discussion seems to have been taking place in Gourlay as takes place now before us.
No.
Right, so
with respect, so what my submission is, in Gourlay, the issue was you didn't make the successful part of the claim was concerned with a recommendation for open conditions, not a decision for open conditions, and it was said that wasn't judicial. The court said no, it is a judicial decision, even though it's a recommendation the Secretary of State has to act upon. You're still acting in a judicial way when you're reaching that decision. It's the same process essentially, but it was a different part of the decision letter. and the claimant had said, oh, differentiate me on that basis, but that was unsuccessful in terms of the judicial functioning, because it was a decision. And again, it spoke for itself. These were the reasons. It happened to be quashed, but it was still a judicial decision. And so there was, against the interests of recovery of costs, there was a public interest that was to be weighed against it, and it is to be weighed, but to be weighed against it is whether or not there's judicial independence, impartiality, the reasons speaking for themselves. That means if the Parole Board doesn't defend it, then it wouldn't be liable for its costs. So that principle applied equally to open recommendation or decision on release order. What it doesn't apply to, or what wasn't discussed, is does it apply, or is it issued before this court, to an Article 5.4 civil claim with damages, which the Parole Board doesn't have a defence to, but doesn't concede, and then doesn't want to pay the costs of having had to go to court over.
As I read what Lord Reid said at 46, I would analyse it into three bits. The sentence you showed us, a body which takes a decision, that sentence. The first piece is, it's a decision in a judicial, and I take your point about quasi, a judicial capacity. So that's point one. Is it a decision in a judicial capacity? Point two is about what then happens. They then decline to defend it when it's challenged, choosing to let the reasons, they decline to defend it, let's take that. And then the third one, let the reasons speak for themselves. Now, there are judicial decisions in which there are no reasons given at the time they're made. That's not uncommon.
Not
Now,
for the Parole Board, it's required to give reasons.
Okay.
The rules require.
Fair enough, maybe, but those three elements are there in that sentence.
Can I take issue with my Lord making it two separate, three rather than two?
Okay.
Because the reasons speaking for themselves and not defending it, if you separate out not defending it, of course, in the county court scenario, not defending it doesn't give you any immunity from costs. You violated somebody's rights under Article 5.4 to delay.
What I'm trying to do at the moment is understand what Lord Reid is saying.
Yeah.
And that, at least as I see it, and I'm not trying to make a point that hurts or doesn't hurt your case, there seem to be three things going on there. One is a judicial capacity, one is about what you do about defending it or not, and one is about reasons. Now, I understand the point you made, Mr. Rule. You say that in the particular facts of this case, you need to look at it in a slightly different way, but those strike me as being, at least speaking for myself, three elements. What I still haven't quite understood your submission to be as to whether in this case the decision which is unlawful in a breach of Article 5.4 is a decision in a judicial capacity or not.
I say there isn't a decision.
There isn't a
There isn't a decision. What the judge finds, we'll come to the judgment. What the judge finds is that you have failed to give him the hearing when he should have had it. That's a violation of Article 5.4, it requires a speedy hearing. It's not a deliberate judicial decision. Now, in the background, there was an expedition request that was refused. There were no reasons given, just one exceptional case. That is not the basis on which there's any award of damages or any finding of Article 5.4 violation. Just happens to be background. There was also an unlawful decision. But the operative part of the claim is the delay period, which the judge finds, which is a breach of Article 5.4, not a decision that had to be quashed. He doesn't bother quashing the unlawful decision because it has no effect.
Okay.
So that's where the damages arises. Now, before I leave, if that's no one was point, before I leave Lord Reid's judgment, could I just go back to page 859, please? At the bottom of paragraph 38, his lordship refers to the discretion within the Davies judgment itself. So the last few lines next to letter F. Lord Justice Brooks' judgment in Davies itself recognised that there was scope for judges to exercise their discretion. See paragraph 47.4, cited at paragraph 4 above here. Your Lordship, my lady, may wait until we go to Davies and you'll see 47.4. The reason I highlight it here is it's an endorsement of it by Lord Reid. There's no demurrament from the fact that this discretion arises under Davies 47.4. And it may be that needs to be better understood in practical terms than it has hitherto been, and certainly may afford some means to compatibility with the proportionality requirements that Article 6 imposes, which I'll come to. So I wanted to just bring the court's attention to that. I think other than that, I can leave his lordship's. So, one final point, sorry, as well as that, his lordship at paragraph 12, page 852. Noted at the bottom there that in the Court of Appeal, Lord Justice Hickenbottom added that it was likely to be open to the prisoner to make the Secretary of State party to any challenge decision in relation to transfer, so that in appropriate cases he'd be able to obtain a cost order against the Secretary of State. So that was a feature of the Gourlay decision as well, that there should in fact be another party who should pay the costs or be able to pay the costs. It was described as likely. I'm not necessarily making any submission that in favour of that description, that it is likely, but it is a basis on which the claim in Gourlay was addressed, that there was the potential for another party to pay. Now, quite what the practical benefit of that would be, given that the Secretary of State in fact pays the Parole Board the amount of money that it pays out as a non-departmental arm's length body sponsored by the Ministry of Justice, ultimately the Secretary of State is the one whose coffers damages and costs come from. But nonetheless, as a matter of who it's awarded against, there was suggestion there of those. And as I say, that does bring me to the end of dealing with Lord Reed's judgment. Just my next point, if I may, the test for Court of Appeal on cost appeals. I know the friends have cited a particular case where a successful appeal occurred. We've included the White Book, which includes the well-known passages. That's tab 13, page 136. But I don't think the court needs to go to that. So far as the factual purchase is concerned, obviously the court has the judgment below. Can I just draw attention to the findings that I've already mentioned to some extent in relation to what the claim is that was allowed? Unless it would assist the court for me to give a nutshell opening of what the facts were, which I could do in a few moments.
I think we have read them. I think we know what they are. Mr. Davis.
I take them as read then. I'll just deal with what the judge's conclusions were.
Yep.
At page 104 of the core bundle. The analysis section, conclusions set out firstly, paragraph 14.1. The board violated the claimant's Article 5.4 right to a speedy hearing, having regard to his circumstances and applying an objective standard of reasonableness. That's the finding. The unlawful delay occurred after the 3rd of
just
August.
unpick what it is exactly that underpins that? What was the process by which the right to a speedy hearing was not achieved? So
if I can just give the brief basics. There was.
If you want to take us, to passages earlier on in which this is crystallised by the parolees, but one way or another, since we've had a discussion about what's judicial and what isn't.
Indeed. Let me just outline in my nutshell. It begins really in the judgment. I don't need to go further, but I can also just give the court very quickly this summary. The appellant was a prisoner who's subject to a tariff, so is an indeterminate prisoner. He needs to be released by Parole Board direction. The tariff is the minimum punishment term, which must be served before any such direction. The law, as the judge sets out, Court of Appeal in Norcoive, the law requires you to have a hearing at or about, and in practice usually just before, the tariff expiry date to decide whether you have rehabilitated and can now be released. The Parole Board will have power to decide whether or not you return to liberty or not. And that's the decision that the Parole Board takes. We don't need to deal with open transfer recommendations. He'd already been transferred to open by previous Parole Board years before. So he's in open, he's progressed well, and he's ready for the parole hearing. So he's directed to a parole hearing on the 22nd of April 2022, which is before his tariff expires. The Parole Board directs a hearing, which is then listed to take place in August. But in fact, on the 1st of August, there hadn't been a report received from someone for whom the Secretary of State's responsible, so the Parole Board didn't list the matter in August. in the meantime, the judge relies on the evidence that is provided as to what progress someone's made, whether or not they're likely to be released. Judge found the probabilities he would have been released because he had the recommendations in place, that the progress he'd made was in place, so that had he had his hearing by this point in October 2022, he would have been released. And the practicality would be he would have a bed in an approved premises available by January 2023. So the judge put all that information together to find that because he hadn't had the hearing when he should have done, and the knock-on effect was that despite you being ready for release, you don't get that hearing to deal with your release. When he eventually does, he is released. He would have been released earlier had he had his hearing on time, because it was delayed with no excuse. And the judge deals with this, but Norcoif Court of Appeal made clear, I think it's 2001, resources is not an excuse for an Article 5.4 breach. You cannot say we don't have enough members to provide hearings. The state has decided to have this system. It has to put in place the resources to give you your time for release when you've rehabilitated. And so there was no defence advanced. Parole Board itself had accepted, just didn't have the number of panels to list it, no conscious reason not to list. And so on that basis, the judge found there was no defence, it was made out, and the period of time, if I go back to his analysis, we'll see the period of time he makes clear during that scenario when the unlawful delay happens. So 14.1, the unlawful delay happened after the 3rd of August 2022, when the hearing should have been scheduled for the 11th of October 22. And
that first bit was because of the report.
There was a delay, yes, there could have been a hearing in August, but there wasn't a report available, which there should have been. And in fact, it was available by the date there would have been a hearing. But I mentioned this point about the Secretary of State's report being missing as a matter of interest, because there can be cases where the entire Article 5.4 breach is the Secretary of State, not the Parole Board. In that case, we say arbitrarily, without principle, the 5.4 breach claimant will receive his costs from the Secretary of State, because he cannot claim any judicial immunity. So, and we say that neither can the Parole Board. And we make that good by reference also to the Section 9 of the Human Rights Act. But for the purposes of the comparison, when you lodge your claim that I've been refused my hearing unlawfully, you don't actually have all the information about who has delayed you, why. You know you haven't had your hearing on time. You know you're suffering your delay, the frustration, anxiety, and loss of liberty that goes with that. But whether it's the Secretary of State or whether it's the Parole Board who actually is responsible for why you're not getting your hearing, you may not know until you've issued. And at that point, it becomes entirely arbitrary. If it's the Secretary of State who happens to be at fault, you might have a claim for your costs. If in fact it's the Parole Board who has not listed a hearing and is responsible, then you won't, on the respondent's case, you won't get any of your costs.
So there were two factors that were relevant. The first hearing was missed because of the report, and the second factor was finding a tribunal to hear the matter. And there was then clearly some complexity in the meantime about what was going on with the judicial review proceedings.
Yes, although the first factor doesn't really feature because the judge focuses on the unlawful delay from the October date when you would have had your hearing.
Yes, but just thinking about what happened on the ground, but so far as the case is concerned, it's all to do with the rights and wrongs of a hearing not actually being offered until October 2023.
Indeed. Yes, indeed. Yes. So the finding of unlawful Article 5 violation is about the period of delay during which there was no hearing. And that's the responsibility of the Parole Board. Although it is funded and recruited and resourced by the Secretary of State, who, if you expand the person standing behind it, is actually also equally responsible as being, if the Parole Board says we haven't got enough members, who has failed to give you the members? But this is a case that's about who is providing you with a hearing date, the Parole Board. They should have provided you with that hearing date on time. If not, they're in violation of Article 5.4. But what they cannot do is say we're in some special category or we don't have to pay costs for that. Our funding body might, but we don't. So my lady, if I can just finish off with his lordship's conclusions and reasons, and I won't go any further in the judgment than these. You have the declaration of unlawfulness for the remedy for 14.1. You have the finding of fact made on the balance of probabilities that the actions in violation by the parole board, the actions in violation of Article 5.4 resulted in detention beyond the date he would have been released. And on the balance of probabilities, he would have been released by that hearing on the 11th of October 2022, and he would have had a bed to go to by the 7th of January 23. It follows, therefore, that the compensatory damages for delayed liberty should be awarded. That's the Faulkner rather than the Sternum scale of damages. It follows, but I'm not going to award additional damages. No. The appropriate level of compensatory damages is £10,000 in respect of the 10 months from 7th of January to the 7th of November. And 14.3, as I say, is the background failure unlawfully to decline to prioritise the case, which had taken place as well, of no materiality to the 5.4 issue.
The DM is the decision maker?
DM duty member.
Duty member.
Duty member.
Sorry.
So that's a parole board member who sits on their own and on paper can decide things, directions, case management, that sort of thing. That decision, if I just invite your lordship and my lady to see that. That decision is on page 212. Of the core bundle. So on 212, the duty member considered the application for expeditional priority. In doing so, reviewed a dossier and didn't have the directions for an oral hearing. So didn't bother looking at the document which says you're listed to a hearing, you don't need a specialist member, 4 hours or so, video link will do, all the directions that have been made in April 2022, didn't look at. But then said the timescales associated with the case were reviewed, appropriateness prioritising or expediting considered, however, concluded circumstances were not sufficiently exceptional to warrant this. And the judge applied divisional court in Bate.
I'm sorry,
Sorry.
I'm lost.
Does your lordship
yeah,
have
I'm looking at the box. That's what you're
the
reading
box?
from, isn't it?
Yeah.
So what's the sequence of events here?
There's an application made.
Who fills in the box?
This is the duty member. This is their decision.
Right. And so why is the duty member saying that directions for an oral hearing were not contained in the dossier?
Because they haven't been. They've been given a pile of papers or a dossier, but the dossier hasn't got the directions from April that have already been made. So what my point is, one the judge made, they didn't even look at the directions that have been made. So they just looked at the dossier.
The duty member is saying, I'm aware of the directions for an oral hearing, even though they weren't included in the dossier. Is that
they would know there's been direction because there's been reference to. We would.
Yes.
They would know it's been directed to a hearing. They should have read, but they hadn't read why it's done for a hearing or anything about the case.
Right, and so this exercise of this exercise of a judicial function.
This.
Yes.
Arguably so.
Arguably, or a quasi-judicial function, or something of that sort, attracts a declaration of unlawfulness.
Is it declared? Yes.
14.3.
Yes, it is. And I was just going to explain, my lord, the reason why it was unlawful is there was established authority divisional court in Bate that there are no exceptional circumstances needed. You should consider on the merits expedition priority requests, and moreover, lack of members to hear them isn't a reason to refuse.
But the reason that there's no damages is because there was no additional.
It doesn't change the.
It doesn't change the 10 months.
Exactly. So it falls by the wayside. It's a red herring so far as anything to do with recovery of £10,000 of damages for your breach of Article 5 for delay is concerned. that was already ongoing, that continued. What Parole didn't do was take an opportunity to stop it. It decided not to bother. And that's on unlawful reasons, as it happens. But that isn't a defence to a 5-4 delay period, as the judge makes clear. Why I think he refers to Bate there in 15.2. And then his lordship deals with the he deals at the end of the problem of panel member resources is in law no answer. That's correct. One goes to the Court of Appeal Authority on that. So it may be convenient while we have the judgment if I also deal with the order made as to cost, so that we don't come back to it in piecemeal fashion. Obviously, different grounds deal with different aspects. Over on page 106, the court will see his lordship said he'd received quite a lot of authorities and submissions. I don't think it's necessary to dwell on those. There is a 20-page set of submissions that were submitted to the learned judge by counsel at the judicial review, other than to say he was invited to do that which we invite this court to accept the law requires, which is the proportionality assessment, the balancing of Article 6 and all of those points. And that document's at page 111 onwards of this bundle. But as I say, I don't think it's good use of the court's time to go through it in detail. You have the appeal grounds which relate to points that have been made there. So far as his ruling, he notes at the top of 107, it was argued on Davies' principles the board had failed to adopt a neutral position, had become an active party, but the judge rejected that. That's ground 8. Ground 7, alternatively, it was argued the parole board had unreasonably refused to sign a consent order, as in Summers' case, but I cannot accept that submission. Indeed, there were 3 without prejudice savers to cost offers from the claimant, but all of those were insistent on the damages of 15,000. Now, just ask the court to pause there. His lordship thought there were 3 and that each of them asked for damages of 15,000. In fact, that's not correct. There were other offers in which there was no sum of damages, but damages to be agreed pursuant to the liability concession that was being offered. I'll take the court today's when I turn to ground 7, sorry, on that. His lordship correctly notes there was no cross offer from the board, but then said, but nor is the board asking for its costs. Well, as the unsuccessful party, the board wasn't able to ask for its costs. And it had, in fact, as we'll see later, threatened costs over not agreeing to transfer out to the county court without any costs of these proceedings being paid. Then his lordship dealt with the principal points, as it were, principal LE. More ambitiously, it was argued for the claimant Article 6 or 5.4 require costs from the parole board follow the event. The costs themselves part of just satisfaction. C, the court must have regard to the claimant's legal aid position. Nothing was identified from the 57 authorities to directly support those contentions. And his lordship said the cost principles applicable to the parole board as a defendant court in Article 5.4 context have authoritatively been identified by the appellate courts, Gourlay and Davies. Before leaving, and that begs the question, of course, we come to on the appeal. Before leaving costs, I should record, in fact, the fact in the present case, which enforces the inappropriateness of a cost order, the clear missed opportunity for an expedited substantive hearing shortly after 31st of March 23. So, and there will be no order as to cost. On the missed opportunity point, I come back to that in relation to those grounds 7 and 8, but there were no costs associated with that. Of course, the only person who suffered was the claimant didn't receive an expedited hearing before the administrative court. What seems to have happened is in the transfer from Birmingham to London, the court didn't pass on that the fee had been paid for a hearing to take place. It had been promptly, but it appears that then things settle in the ether a little bit. It's accepted by those instructing me that there should have been more active chasing at times, but essentially none of it matters in the sense that there are no costs associated with that. In fact, the delay meant that it actually narrowed down the issues, so there was no systemic challenge that came before the court. Those are the short reasons given for declining costs. There was then an appeal on the cost point. That appeal document is at page 213. And in fairness to the learned judge, it is the list of grounds as opposed to a detailed exposition of them. And his lordship at page 108 onwards made an order declining permission to appeal in the terms that he did, noting nonetheless points of principle that the Court of Appeal might wish to address, which had not been elaborated upon before him. He refers to paragraph 109, page 109, points of principle heading, to paragraphs 2 and 3, and paragraph 7. He invited the explanation to be given with targeted authority to this court. I come back to the points of law in a moment in relation to Article 6 and to Davies, but it's evident from the judge's decision that he did not take the starting point of the general rule that you recover from the unsuccessful party because of the identity of the parole board as the defendant. That reliance was placed on Parole applying Davies, and that there was no particular consideration of the circumstances or effect of non-recovery of costs upon the damages award or the claimant's circumstances. So there is no consideration of departure from the general rule, as it were, on an individual consideration of the matters that we've addressed already and that I come to in my further address to you.
Is there consideration of non-recovery of costs on the circumstances of litigants normally in ordinary civil cases?
Well, the court has a discretion over costs, so it always has the ability to consider and weigh anything of relevance.
Well, yes, but I mean, we're obviously familiar with cases when there's been heavily contested civil proceedings, and in many cases where the amounts that have been racked up in costs are well beyond the amount that was originally in dispute. And the incidence of costs and where they're going to fall can be catastrophic for the individual litigants. But this court can't make different orders for costs because of that.
No, I understand. The difference we submit here is that when Article 6 is in play and you have a violation, and particularly a fortiori, not only, but a fortiori when the state is the responsible body for the violation, non-recovery of costs can only be justified if it pursues a legitimate aim and an assessment of proportionality renders it an appropriate balance to strike, where the weight of the consequence for the individual.
I understand that that's the submission, but it appears that you're putting up a proposition, which is that what I would understand to be the general position, which is that in civil litigation the costs will land where they land, and they may land very heavily on a litigant, may ruin them. But that's not something that leads to different orders for costs. But you're saying that there should be a different rule where there has been a human rights claim, A, and B, where the paying party is the state body that was responsible for the violation.
May I put it slightly differently?
Yes.
First, I say it should be the same rule, the general rule, that the successful party recovers. That would apply in the civil proceedings my lord's talking about, even if a different one's been made for another reason.
That's a different point, as it seems to me. That what I'd noted was you're saying is that there was no consideration of the non-recovery of costs on the circumstances of your client.
Correct.
No consideration of non-recovery of costs.
Correct.
That's the point of that's the focus here. And as I understand your argument, you're saying that consideration was mandatory because it was a human rights claim and because the violator was a state body.
Correct.
And so that is different from the normal run of civil cases.
Yes, well, my lord, I only make the point that costs are in the discretion of the court, even in that scenario. One isn't bound in every case by the general rule. But the general rule would be the starting point.
Doesn't say in a civil case, this is going to be catastrophic for Mr. and Mrs. So-and-so, who've lost the proceedings and the appeal.
I understand.
And we feel terribly sorry for them, so therefore we're not going to order costs in favour of the multinational company who's won.
My Lord, I don't demur at all. I understand what my Lord's saying. What I say is that when you are making a decision on costs, the general rule is why my Lord is saying in that scenario, I would expect, the costs are falling where they fall, because the successful party is recovering their costs.
Yes, I understand the strength of your point about the general rule, but I don't understand at the moment, or at least I'm asking myself, whether there is another step that has to be taken in cases which are human rights claims where there is a state violator.
Well,
that's the only.
My submission: there is an additional step that has to be taken if they ought to comply with Article 6, access to the court in that case, as the authorities that I'll come to make clear. So yes, there is, but the starting point is not that I'm asking for a different rule. I'm asking for the same rule because the same rule is consistent with the policy of recovery for your violation. So the general rule that your successful party recovers has been disapplied by reason of the parole board's identity, and that I take issue with. I think that was where I was at cross purposes with my Lord, but it's not that I take issue with the principle that the general rule applies with great force. It is the departure from it which requires the proportionality justification, which we're seeing in this case, is absent. So, my Lord, the scenario here is one in which there's success and there is non-recovery of costs, and the consequence of the non-recovery of costs is that there is no recovery of the damages or just satisfaction against the state for the violation. Now, the factors which are of particular importance, I can perhaps set out in a shorthand commencement to take into the authorities in this way. Firstly, the incident proceedings concern determination of civil rights protected by Article 6, access to justice being principal. Secondly, we say the order of recovery of costs for the successful party is required if the order is to be compatible with Article 6. Court's duty under Section 6 of the Human Rights Act. That requires the order to be proportionate. Which requires consideration of the relevant individual circumstances and the impact on access to justice as well. My third point, I've dealt with the particular underlying right and concern of liberty that we're concerned with, and indeed the subdivision of that to the delay type of Article 5.4 claim, where just satisfaction is required in damages. One thing to add to that is Article 5.5 is a special addition in the Convention, and we see reference of a similar nature in Section 9 of the Human Rights Act. But Article 5.5 guarantees the right to damages for a violation of Article 5 in a way that other articles don't. That highlights really the special concern over liberty and its breach at the hands of the state that applies in Article 5, an enforceable right to compensations, Authorities Bundle, page 6. The award of damages, fourth point, the award of damages, as I say, is part of just satisfaction applying the Strasbourg Court's approach. Article 41 the satisfaction, costs form part of that. You can see that from the practice direction, which is at tab 2 of the authorities. So the practice direction of the European Court of Human Rights, at page 10, general principles, just satisfaction is afforded under Article 41. For the actual damage, it may cover pecuniary damage, non-pecuniary, and costs and expenses. That's the basis upon which awards are made.
I'm sorry, I missed that. I no doubt it's
I'm
there.
sorry,
I just didn't see it.
on page 10 at the bottom, general
Oh,
principles.
bottom of the page, sorry.
Yeah, sorry.
Thank you.
And it retains discretion of similar nature to that which we've discussed earlier over unreasonable level of costs and this sort of thing. Then if you go to page 12, there's a specific section on costs and expenses, those which are necessarily unavoidably incurred in trying to prevent the violation from occurring or trying to obtain redress. So actual costs subject to reasonableness, recovery in the usual way. The point really is that these are made without distinction from the damages, compensated and all part of the just satisfaction, that you shouldn't have lost out on bringing the vindication of your right to the court, unless there's some particular interest, and this recognises it, as do the cases, particular reason why you shouldn't be recovering, for example, misconduct by the litigant.
Sorry, what part of that are you parsing? That summary came from which paragraphs?
So in terms of the ability to award costs if they're reasonable, etc. So paragraph 4 on page 10, the court may decide if there are reasons of equity to award less than the value of the actual damage or the costs and expenses. So it's free. All courts are free, having adopted the correct approach and proportionality, etc., to decide whether you've acted in some way that reduces your damages or in some way that reduces your costs. Those are the principles that we've spoken about this morning a little bit, which are not in dispute. The question is about what happens where you're successful in your claims, we'll see from the authorities, but you still don't recover, and the consequence of that is you don't get your damages.
This is talking about just satisfaction awarded by the Strasbourg court itself.
Yes, it is. But when we come to the cases, they're dealing with domestic decisions not to award costs being found to violate Article 6. So that's what I'm about to take the court to, is the dicta on how Article 6 requires, where you have a violation and damages are at stake.
I mean, I'm not seeking to challenge what you're telling us, but I'm just trying to situate this practice direction. This is a practice direction of the Strasbourg court. Mm-hmm. It's not a practice direction of the administrative court.
Indeed, indeed. My lord, the reason I mention it is Section 8 of the Human Rights Act is that embodies what's often referred to as the mirror principle. When you have Lord Bingham in Greenfield, and you actually have Lord Reid in this context in Faulkner and Sturnham, talking about how we try and mirror what Strasbourg would be awarding for the violation, rather than you have the expense of going to Strasbourg. The domestic courts give it to you. That prevents you being a victim any longer. It brings to an end the victimhood in the way that the court is able, and it should be done domestically, and it should be done in the same way that we're predicting Strasbourg would have done it in the case, by reference to principles that Strasbourg espouses. So when you come to Article 41 and Section 8 of our Act, the question is, in terms of costs, if the Strasbourg court regards that as part of the just satisfaction, i.e. in order to have your redress for your violation, the just satisfaction should include costs where there's reason for that to be so. The domestic courts are entitled, and indeed by the Human Rights Act itself, enjoined to have regard to the Strasbourg jurisprudence, Section 2 of the 1998 Act, have regard to that in deciding what the order of the domestic court is. So We can essentially, if it helps, also ignore the practice direction and move on to the cases because they also
Well,
deal with.
I'm really anxious to get to Davies at some point because you know it so much better than I do.
My Lord, I was going to begin with the Article 6 case law now, and then you could see Davies in the light of it. But given the indication, can I take you to Davies and we'll see what was said?
I think that would be helpful.
It's tab 23 of the authorities. Judgment of Lord Justice Brooke in 2004 in a case concerning a coroner. That case wasn't one concerned with damages or recovery. It happens to have been a legally aided claimant, but that's not, I think, an essential differentiation. But it is relevant to some when we look with care at some of what His Lordship said. So paragraph 1.
It's an unsuccessful claimant. JR sought to challenge the decision of the coroner. The coroner appeared. The judge dismissed the claim and made no order for costs legal aid taxation. Is that the scenario?
I thought it was a successful claim. I'm just.
The claimant then appealed. Was successful in the appeal.
Thank you. That's good. Right. Okay.
Grateful. I'm glad I wasn't so far wrong. But you did test me, unfortunately. But I can't claim to know everything.
All right. So successful appeal, and this is the afters of the successful appeal.
Indeed, and this is specifically about the cost recovery against a coroner. So the point to start with, I think, just to put it in its full context when we look at the dicta on the principles, is in fact Mrs Davies was legally aided, paragraph 1 on page 273. The court confirmed that the jurisdiction that it was exercising stems from section 51 of the Supreme Court Act 1981. That's on page 274. To the extent that's relevant, of course, that's the domestic provisions. There's no recourse at this point to Human Rights Act or Article 41 or anything else in terms of cost considerations. It's a 2004 case looking at the Supreme Court Act as it was, Senior Courts Act. And it notes the historic concern, although no longer the case, in paragraph 2 as well, as to whether coroners would be personally liable. These days, they're given the indemnities by local authorities, provided they act reasonably and don't bring proceedings themselves. But that wasn't always the case. So historically, there was a concern that you would be ordering costs against an individual coroner, as the concern was also with individual justices. So unless they'd acted in a flagrantly improper way themselves, the court would not generally be putting costs against them for having got something wrong in the course of their judicial, perhaps voluntary posts at the time. But certainly that was a historic concern that would have given rise to the rule. But the court does look at what the current situation is. Now, if we go then forward to page 280, that is the summary given of the previous case law having been looked at. I think Mr. Lord Justice Hickenbottom said magisterially, or in any event, a very thorough look through older case law on coroners. And the survey leads His Lordship to paragraph 27 on page 280. It wouldn't be ordered against the inferior court or tribunal unless it behaved improperly in a flagrant way, or unless it appeared at the hearing as a list to contest the application, or it declined unreasonably to sign the draft consent order, which might obviate the costs of an unnecessary hearing. So those were the principles that Justice's cases had developed, and then, as he says at 28, they crossed over to coroners as well. His Lordship then looked on page 283 that some cases where costs had been awarded and looked at what the connection was between the cases in which costs had been awarded, or the explanation of the principles at play. And what is important to note is that given these are not damages cases, legal aid would mean that someone hadn't paid for their own representation. Whether or not someone had legal aid was seen as a factor in some of the decisions that provided costs. So at 35, letter D, number 3 is the applicant was not legally aided. And so in the case of Kent Maidstone District Council, ex parte Johnston, Lord Justice McCowan had made clear that there was going to be a cost for that reason. And at 36, another case, Lord Justice Phillips and Mr Justice Hooper, as he was, made an order for costs against the coroner, who made an affidavit and took no part. Lord Justice Brooke didn't think it followed the established practice, but he noted this was another case in which the court was concerned about its inability to award a successful applicant her costs from another source. So we see examples where the courts were concerned to award costs where there wasn't legal aid and there wasn't someone else paying them, even in circumstances where a coroner who had been unsuccessful hadn't taken part and hadn't contested the case. And then the further case of Touche, in which Lord Justice Simon Brown had awarded costs, and you can see the Constitution of the Court, paragraph 38 here. His Lordship spends some time analysing that again as to why some judges were awarding costs not in accordance with just the standard practice. At the bottom, letter B, the deceased husband did not qualify for legal aid. No issue as to the cost of the coroner's appeal, which followed the event when he lost the appeal. And in ruling in favour of costs, Lord Justice Simon Brown, paragraph 40 is summarised. So the concern that Lord Justice Brooke identifies in the alternative line of cases is that there is a discretion to award costs if it's going to leave the applicant out of pocket rather, who's come to the court successfully. And at 42, there's quite a long passage dealing with what Lord Justice Simon Brown, as he was, had said about the need for there to be this type of discretion. And I think there are various occasions the court was imploring Parliament to give it a wider discretion over central funds awards than necessarily Parliament ever has. But then we come on to see what his lordship makes about all that in setting what's become the Davies principles. At 44, between D and E, number 2, the government's continuing unwillingness to permit the courts to make an order that an applicant's costs be borne by central funds in an appropriate case. 5, down between E and F, 5 on the left-hand side, the growing incidence of High Court challenges of applicants who are not supported by another source such as legal aid or a trade union. And at 45,
6.
At 6, the effect of Article 2, explained in recent judgments, including our earlier judgment in the present case. That is, at that time, about expanding coroners' inquests into satisfying the state's obligations under Article 2.
Yes, I only point to it as an indication that the court was obviously aware that the Human Rights Act had come into effect.
Oh, yes. Yes, it would have been in effect for 4 years, I think, by then.
Yes.
It might not have been in force at the time of the events in question. It's not clear from what I've read when the inquest was.
Yes, and I hadn't read the reference there as being in reference to issues of Article 2 liability, vindication of rights, rather than the scope of inquests and the nature, the likelihood there were going to be more challenges brought to the court because the state has to comply with the Article 2 obligation. So that we have seen a difference in coronial practice as a result of Article 2's implementation through various investigative duties. And I read it as relation to that, but
Yes,
I take the lady's point, I'm grateful. So 45 is where we come to the 4 principles, and it is important to note all 4 of them. Firstly, dealing with the CPR, successful parties, unsuccessful parties. The court notes that and says if the conduct of the parties take a studiously neutral position, that's a factor. Conduct of the coroner, neutrality. On the other hand, the emphasis on justice and fairness in CPR Rule 1.1 will oblige the court to examine anxiously whether a source of public funds is available if a privately funded litigant like Mr. Touche has to initiate court proceedings in order to obtain an inquest into the death of a member of his family. So his lordship's not disapproving in any way of the other line of cases, such as Lord Justice Simon Brown and Touche. He's explaining why they exist compatibly with a general approach. And so, very importantly, alternative someone else meeting the costs is a factor, even under the Davies summary. The second point is about the central funds point again. Then Roman numeral 3, 4, I think one can go over slightly. So then you get to 5, which is important, and one of the reasons why when we come over to 47, and endorsed by Lord Reed, we see this discretion arising. But there was a dilemma where the applicants had to pay for costs of a successful High Court challenge, and there's no readily obvious source of public funds to indemnify him for the expense to which he's been put. So these were not damages claims where there's issues about loss of your damages, but indemnify. You shouldn't be out of pocket for having brought the claim. Your costs should be being met, not being repaid, not you repaying a loan out of your damages, essentially. He noted at 6, towards the end there, it would appear unjust that a private citizen should have to be put to heavy expense in order to oblige the state to perform its duty properly. And then we have at 47, in reference to the general practice, 47.1, the established practice of the courts, flagrant instance of improper behaviour or unreasonably declining or neglecting to sign a consent order. 2, established practice, treat an inferior court which resisted an application actively by way of argument in such a way that it made itself an active party, would become costful of the event. Or 3, if, however, an inferior court or tribunal appeared in the proceedings in order to assist the court neutrally on question of jurisdiction, procedure, specialist case, and the like, established practice treated as neutral, so it wouldn't make an order in favour or against it. But 4, and it's important, given what he said about this other line of cases, not to stop at 3, there are, however, a number of important considerations which might tend to make the courts exercise their discretion in a different way today in cases in Category 3. So just because you start to be in Category 3, the neutrality, not active part, judicial decision, you don't stop there. There would be other important considerations. So the successful applicant, like Mr. Touche, who has to finance his own litigation without external funding, may be fairly compensated out of a source of public funds, not be put to a recoverable expense in asserting his rights after a coroner or other inferior tribunal has gone wrong in law, and where there is no other very obvious candidate available to pay his costs. At 48, even with that discretion of 4, his lordship did not find this outcome at all satisfactory. But it stems from Parliament's unwillingness to allow the court to ensure reimbursement through central funds. And then reaching the decision in Davies, at 52, you'll see his lordship refers to, as far as the present case is concerned, the claimant's been in receipt of legal aid throughout. So not in the same position as Mr. Touche. Of course, it's not a case where being in receipt of legal aid is going to cost you anything. The point is there's been no cost to the claimant and no loss from them taking their damages and using that to pay for their legal representation. There are no damages. So the practicality of the effect is there. And of course, the court agrees with Lord Justice Brooke, and Lord Justice Longmore also adds the payment of costs middle ground, where it's the costs have been increased by the way in which the other party has acted. between C and D on page 288. So what the appellant submits about Davies is properly approached. The concern over a party who's come to vindicate themselves in public law terms, even if it happens to be against a coroner, it's still a concern for the court rightly that that person should not be left out of pocket for having done so, and that is to be balanced against the usual neutrality point where the court might otherwise not have imposed costs upon the coroner.
So the outcome on Davies was no costs before Moses J, but costs of the appeal.
Indeed.
And what had happened was that the law had changed between the two hearings.
No, I think
the appeal against Moses J was allowed, but only because, I mean, not through any fault of the trial judge, but because there had been a change in law in between the two hearings. I think that's what's said.
I'm afraid I can't. The appeal costs were treated slightly differently to first instance costs. There is some dicta, I think it's in Davies, not just elsewhere, that on the appeal, the cost would more readily be ordered against the other party in any event than at first instance neutral stance.
The way I'd understood it, and forgive me if I got it wrong, is that there's no question in Davies on the appeal. The coroner's side, as it were taking an active part. They were on the appeal and they were arguing against it, and they lost.
Indeed. Indeed. So I think yes, I think at that stage there was a difference of situation in any event. So with that analysis of what Davies actually says, I don't know if it's
going to now be looking at what has changed and what's different between that decision over 20 years ago and now that should lead us to take a different approach. Is that the process, the thought process that we need to engage with?
Well, yes and no. I think I need to be very clear. So let me put my case out in this way. What I say about Davies is properly understood. There is clearly recognition of a discretion to ensure that the party isn't left worse off.
Yes, and I appreciate that you've got arguments to make about what should have happened in the individual case, even under a Davies regime. But the bigger point that I think we're being asked to consider is whether the Davies regime should continue or not. And as to that, does Gourley tell us that we need to look to see whether there has been some more contemporaneous information that should cause us to depart from what you've been taking us to in Davies?
My submission is Davies doesn't deal with all of the other material. So yes, I think my answer is yes, but not because I'm departing from Davies, but because Davies doesn't begin to deal with it. So far as it deals with the discretion, it's clearly there, and it's consistent with what I'm now going to say.
I just want to understand before you embark on more detail as to whether you're saying that you want us to you want us to change what you've described as the rule in Davies. Appreciate it that it's a multifaceted reasoning, but whether you want us to change that, or whether you say it doesn't apply to what we're concerned with here.
I think I invite an addition to it that makes clear the obligations of the court that arise under Article 6 in a judicial challenge, but also to make clear it doesn't apply in the same way to a challenge which is concerned with a delay over Article 5.4 violation, because it's not a judicial act that attracts the rationale of let the reason speak for itself.
So would it be correct to understand that you're asking us to amplify it for the sort of case with which you're concerned?
No, I'm asking you to amplify it more generally, and I'm asking you to disapply it or not to regard it as having ruled upon what the proper approach is in this case. So yes, that's the distinction.
Amplify and disapply.
Indeed.
Thank you.
I distinguish it from applying in this situation. I respectfully submit that it needs amplification in relation to compliance with Article 6 in a judicial decision case.
So it'd be better to say amplify and distinguish.
Thank you.
Thank you.
I think it would help just to, if I add in the look at Gourlay Court of Appeal at this point as well, just so that you have the final word, as it were, on what this court has previously looked at in relation to Davies and its application here. So this is tab 37. We've already covered off what the case was about. The ground of appeal was that Davies shouldn't apply to the parole board at all. It's a coroner's decision, shouldn't be applied to the parole board. So that you can see at paragraph 33, page 722. The sub-argument to that was it shouldn't apply to recommendations for transfer. That's paragraph 44, page 724. So the decision is essentially not any alteration or amplification of Davies, but simply whether or not it carried across to the parole board and whether it carried off to the parole board on that particular issue. Now, a couple of points to note from His Lordship's judgment, and we've seen what Lord Reid said ultimately about it as well. The court looked at page 719, paragraph 23, at the litigation strategy that there then was for the parole board. I draw the court's attention to this because I do make some observations about the litigation strategy that the board currently has, but the board at the time had a litigation strategy set out at bottom half of page 719. Bottom of paragraph 24 on that page, last two lines. In any form of litigation, the parole board will first consider whether it wishes to concede. So it makes a positive decision whether it wishes to concede. Where it decides not to, over the page, the rule at the time was, or the policy at the time rather, the parole board will not normally seek to defend a decision of a panel to refuse early release or recommend a prisoner's transfer to open conditions. The parole board will normally defend other types of judicial decision and all administrative decisions. The parole board will defend private law claims for damages. So, applying its litigation strategy, there would be far fewer cases in which the parole board would not be active. Top of the page, will not normally seek to defend a decision of a panel to refuse early release or recommend a prisoner's transfer to open conditions. That's the Gourlay case. That was the decision that was under challenge. And in fairness, a lot of parole board challenges will be directed to that, but others that fall into the other categories won't. Then the court looked at Davies in some detail, page 720 to 721. There isn't disapproval, it seems, well, my submission, no disapproval at paragraph 29, reciting what Lord Justice Brooke had said in paragraph 47, which we've just looked at, paragraph 45. So that includes at letter C, obliging the court to consider whether a source of public funds is available to indemnify the applicant for the expense of pursuing court proceedings to correct the administrative decision of an adverse effect on his rights. So that's CPR Rule 1.1, overriding objective. Paragraph 33 over the page, as I say, is sole ground, doesn't apply to the board. And then some consideration. His Lordship refers to binding authority upon him, but Lord Reid explains that because he actually conducts an examination more detailed than that, it wasn't in the technical sense, barring himself from looking at it. You then have the ratio is in application to the board, page 730 to 731. 61 accepts that there's no longer, sorry, 62, accept that there's no longer a problem about coroners or tribunals not having funding sources for paying costs orders. And so paragraph 64, which is one that the judge below referred to, 61 and 64 he referred to, it's a court, and in his Lordship's judgment that applied also to the recommendation point, not just, that's what paragraph 65, the long paragraph is yes, it applies, and it applies to this decision.
And specifically, it applies for Article 5.4 purposes, is what it says in 64.
Yes, because Article 5.4, you have to have a court review your detention speedily. And so domestically, we treat the parole board as a court for that purpose. That may not be, as Lord Reid said, I think, it may not be determinative of how you treat costs, etc., against the body, but I'm not disputing, if it helps, that the board can make judicial decisions that would be under challenge. What I say about Davies is you have to be careful about the Davies rules being properly applied in compliance with Article 6 obligations in a situation where there's a successful claim against a decision of that nature. But what you also have to be alive to is the rationale for that let the reasons speak for themselves point is very different to recover your damages for an unlawful failure to give you a hearing. And it just happens that it's the parole board's fault rather than someone else's fault. Do you receive your costs as well as your damages? As to which there's no judicial independence or impartiality point involved. So my submission is that doesn't, in applying Davies, it doesn't begin to limit the exceptions that I was looking at with Davies, or was indeed considering doing so. It was simply about bringing that regime over, which it did. And now then, if I may go to the authorities that support grounds 1 and 2, which invoke Article 6 and the proportionality issues that come into play, where you do have the determination of civil obligations of this nature before the court. Firstly, a preliminary point on grounds 1 and 2. This is not a challenge to some democratic legislative choice Act of Parliament. Some of the authorities that Malone Friends cite are those concerned with proportionality assessments for legislative choices by Parliament, Coventry and Lawrence, for example. But even in that case, Lords Newberger and Dyson made the point proportionality and cost assessment is different from that. But the proportionality of the act taken by an authority is again different from how one deals with democratic acts of parliament that are under challenge. In any event, the application of the Davies principle, at first we say that in the way the judge appreciated and applied Davies as a carte blanche parole board means no costs, led to a failure to evaluate the proportionality or to evaluate the legitimate aims that might be at play, and why there should be any such denial of recovery. If I can take as read perhaps the engagement of Article 6, not an issue, with cited authority for that. The means of vindication by the Act, Section 7, the court will be familiar with as a victim entitled to bring proceedings and entitled to do so through a judicial review court as well. Of course, for us to be talking about the Davies approach or anything else, the defendant is a public authority. Human Rights Act is involved, and the mechanism for vindicating the right procedurally happens to have been the judicial review process, because of the point I made at the start that it was an ongoing breach at the time. on that case I mentioned earlier, just to give the court perhaps the references to it, is the Jordan's application for judicial review Northern Ireland case. This is a Supreme Court case at tab 42. And in that case, the principle for which I refer to it really is that you can't have an obligation to stay proceedings, which have been the issue there, or to postpone recovery or challenge to unlawful delay on the basis that it's more convenient to, for example, assess damages at the end of it. There was emphatic, and in fact the Northern Irish Court of Appeal had moved since the case had begun to change the position as well. There was emphatic endorsement of the point that I think the court already indicated to me it has in mind earlier, which is that you're not required to sit on your hands and wait until the delay comes to an end organically. You can vindicate your right by taking action to compel the end of the violation. His Lordship dealt with cases there by judicial review that sought declaration and damages for unlawful delays in inquest proceedings, attracting Article 2 protections. The only distinction, his Lordship essentially makes the point, I think without going to it, I can say the point that I've already made, unless the court wished to see chapter and verse. It's paragraphs 29, 31, 33, and 38. And in that case, at 42, the Court of Appeal had failed to consider the proportionality in the particular circumstances of the case. That's page 842. So it's strong dicta. I'm tempted to take the court to it, but I think for the purposes of those principles, you have the point and you have the references if need be. In the appellant's skeleton, paragraph 25, we set out a claim for compensation and costs is within the meaning of Article 6, leaving costs only proceedings, and then turning to the breach. Article 6 is concerned with ensuring, as the court knows, fairness of proceedings, but also with access to justice, access to the court. And it's in that respect it was considered by Lord Reid in the Unison case, which is tab 44. I think it's worth going to this case briefly. It's a domestic authority on access to the court and the impediments to it. So tab 44, please.
This is the tribunal fees case, is it?
It is, yeah. So by, I think it was statutory instrument, but certainly by Executive Act, there'd been fees increased for employment tribunals, which were under challenge on the basis of putting it out of access to justice, many people who could not afford those fees to access the court. What I invite the court's attention to is the way in which the courts assess whether a provision or a measure or order taken is interfering with access to justice, and the fact that it doesn't need to render it impossible, for example, to access a court. It's more about the hindrance that is provided as an impediment. So let's start at page 894. His Lordship explained that impediments to the right of access to the courts can constitute a serious hindrance, even if they don't make access completely impossible. And there would need to be, any hindrance or impediment would need clear parliamentary authorisation because it interferes with the right. Paragraph 110, page 902. The curtailments towards the end of that paragraph can be only to the extent reasonably necessary to meet the ends which justify the curtailment. So in short, he's talking there about the proportionality being against the legitimate aim. So letter F.
What paragraph?
Paragraph 110, please, on 902. Letter F. Limitations must pursue a legitimate aim there must be a reasonable relation of proportionality between the means employed and the legitimate aim sought to be achieved. So you've got this familiar dual test to proportionality assessment there. And this in the access to justice context. And Article 6. At page 903, 112, the ability to pay fees is not determinative of their proportionality. Consider many more factors than that. And he refers there to the Teltronic CATV case. And between B and C, it has emphasised that financial restrictions on access to a court which are unrelated to the merits of a claim or its prospects of success should be subject to particularly rigorous scrutiny. And then reference to the Stankov decision of the European Court 113, Stankov and Bulgaria, demonstrates even a fee which the litigant can afford can violate the right of access to justice. In that case, at letter E, although the aims pursued by the imposition of the fee were compatible with the administration of justice, the fee was disproportionate. And in that case, as you can see there, the Lord Chancellor said that was domestic proceedings in which the state was the defendant, so you shouldn't apply it to employment tribunal fees. His Lordship said certainly that feature made the violation of Article 6.1 particularly egregious. The state was taking away with one hand the compensation which it had been ordered to pay with the other. So whilst Stankov could be distinguished from employment tribunal cases between employer and non-public authority employer and employee, that doesn't apply here, and that's what his Lordship had to say about the egregious nature of taking away with one hand what you have to pay as damages in the other. I don't propose to go to the molested assist.
The Stankov principle was that the applicant was required to pay at the conclusion a fee equivalent to 90% of the compensation that had been awarded to him. So that was the court fee in that case.
Yes.
Yes,
and the reason for that was not that he hadn't succeeded, but that it was 4% of what he'd calculated his claim at. In domestic terms, it was an exaggerated claim. So, but even though it was an exaggerated claim, given that it was difficult to get an accurate claim, the court said that was a violation. So the legitimate aim was, we don't want people exaggerating their claim, so we charge fees on the volume of the claim to make sure you don't do that unnecessarily, you'll pay a bigger fee. This is in Stankov, we've got that at tab 28,
yes.
Paragraphs 14 and 15 on page 426. So it's 4% on the initially claimed value of the claim rather than what he actually got.
Thank you.
And the issue in that case was the excessive court fees hampered access to the court. And as you know, the violation was found. Paragraphs 48 and 54, Stankov deal with it. But there are other, although Stankov's in the bundle, there are many other cases that have dealt with this point which are relevant as well. But that I wanted to highlight, Lord Reid had noted and said about it. Two cases I don't propose to go to unless the court wishes to. Christian Institute and Abortion Services have been cited by the respondents. Those are challenges to legislation ab ante, proportionality challenges. My submission is short that they don't demur from unison being the correct test that you would approach this type of case with. On to then some of the European case law to demonstrate the practice that this court is required to have regard to under Section 2. Moscow and Croatia is tab 54. And this is a relatively recent case. We have Grand Chamber authority as well within the list of cases here in the authorities bundle, but it's useful to take this one as a summary point. In that case, there was a complaint about non-recovery of two sets of costs. The Constitutional Court firstly had refused to award the costs of her first complaint of a violation of a right to a hearing within a reasonable time. So there had been that violation but no costs. And she couldn't obtain the costs of legal adaptation in a purely acceleratory remedy where she'd asked for expedition of some enforcement proceedings separately. And so those are the two sets of costs, paragraphs 22 and 25 in more detail. But I think if you go to 53, that's on page 1178. The complaint the court deals with concerns the Constitutional Court's refusal to award her the costs of her first constitutional complaint and the inability to recoup the costs of legal representation which she'd incurred in pursuing the purely accessory remedy under the 2013 Courts Act. So that it's non-recovery of two sets of costs is the issue. The Constitutional Court had awarded a declaration, a mandatory order and damages, but not costs. That's paragraph 27, page 1171. And it was applying a law which you can see at 36 under the Legislative Act, which was unless the court decided otherwise, each participant in proceedings bore their own costs. So there was a more general provision that had to be considered, and it was part of the background there. And then if we come to the principles, paragraph 79 onwards, page 1183. Relevant principles summarised in a Grand Chamber decision of Zubac and Croatia there. The restriction of the right of access to a court not be compatible if it doesn't pursue the legitimate aim and if there's not a reasonable relation with proportionality between the means and the aim. 80. Imposition of a considerable financial burden after the conclusion of proceedings, whether in the form of fees or costs of legal representation, may constitute a restriction. There's citation of Dragon and there, which is a case against Croatia. That case is in our tab 48 of the bundle, where the court decided that it wasn't incompatible per se that each party bear their own costs. Paragraph 69, page 997, if note is helpful. But the amount of costs had to be considered against the particular circumstances, and what it did say in Dragon was how important it is that the state is the defendant. Give me 1 moment. I think you have the point from Lord Reed already. But similar point about where the state is the defendant. Paragraph sticking in Moscow, paragraph 86. And there's a few paragraphs on these pages actually, but just sticking with 86. There were no particularly weighty reasons to justify the disproportionate financial burden on the applicant, having had regard to her income. And that situation in itself makes a restriction of access to a court disproportionate, as it renders the litigation pointless, the applicant's right to a court merely theoretical and illusory. If we go back up to see that, the point that the court's referring to is actually paragraph 85. The costs of the complaint exceeded the compensation. Middle of, 3 lines into paragraph 85. So this was exactly a case where the applicant succeeded in constitutional claim. The general approach was we're not going to award costs to either party. No particularly weighty reasons given to justify, so her conduct hadn't required it, etc., etc. She was just a standard successful party vindicating her rights, and on that basis, the court found that this was disproportionate because
this is a challenge to a general rule of no order for costs.
I'm sorry, Lord.
This is a challenge to a general rule of no order for costs.
It's individually applied in Moscow. So they don't say you can't have that rule at all. They say you have to look at its application to her circumstances. So there you had the damages award, the ratio of that to the costs. Another factor that we can see from the authorities is whether someone needed to have legal representation. So certain of the no-cost places are the lower tier tribunal types where you are expected, you might be able to be an applicant and a litigant in person. And so there are certain cost rules that follow that expectation or that potential. But those factors all need to be individually considered to justify whether or not her not receiving a costs order was an interference with Article 6 and incompatible with it, as in that case the court finds it was. And similarly to what Lord Reid said, if one looks up at paragraph 83, group of cases against the state, public authorities, that case law wasn't rendered inapplicable to private law cases as well, but it still came down to the risk of any mistake. This is the end of paragraph 83. The risk of any mistake made by a public authority must be borne by the state itself. Errors must not be remedied at the expense of the individuals concerned. See Zustovic, paragraph 100, in the case cited there. Being understood that poor organisation of its judicial system constitutes such an error or mistake. So the court is emphatic about the way in which the proportionality assessment applies, especially if, as in the instant case, you're talking about the violation coming from a public authority. And even more specifically, to where it's a failure to organise speedy hearings, even outside of Article 5.4, but in the Article 6 scenario, it's not being a detention case, those principles apply. So a number of cases are cited in these paragraphs for support for the principles. One that's worth perhaps mentioning is the Klaus and Croatia case, which you can see there. Klaus cited above at the bottom of paragraph 82. That was one where the rules about costs were considered because a legitimate aim was to discourage inflated claims and unwarranted claims. So you could not necessarily recover costs if you had your inflated claims and unwarranted claims. That meant you had partial success, and there were legitimate interests in discouraging that in terms of cost rules. But in that case, the court found a violation where the costs had not been incurred by the conduct complained of. So the applicant who didn't recover all their costs, their conduct didn't cause any costs, and the minor procedural misconduct led to unacceptable consequences where 79% of damages were lost in costs. Can I just show the court this, given its relative similarity? But tab 32, page 594. Paragraphs 95 to 97. So as well as unacceptable consequences, it was paradoxical that the state take away with one hand what it was being ordered to pay damages, in that case for police assault, was paradoxical. And if I return to complete Muskai, back at tab 54, page 1184, I mentioned consideration as to whether legal representation is a factor. That's paragraph 90. Court decided on complex questions concerning the protection of fundamental rights and freedoms. Perfectly proper to have a lawyer represent you before the Constitutional Court. So far as of any relevance on matters the court, I think, has read about the intellectual quotient that is attributed to Mr. Fitzgerald and his borderline IQ. And the court found it as an unacceptable, disproportionate result that there wasn't the recovery of costs and a violation of Article 6 funds found. So that case is useful in the sense that it brings together a number of the authorities that are also in the bundle, including Grand Chamber. We submit that the Strasbourg authorities make very clear, and they sing really with one voice, it's a clear line of jurisprudence and Grand Court included for the purposes of the Section 2 approach, Hicks, paragraph 80 that we have in the bundle, which the court will be familiar with, I'm sure. But there is a general approach that a successful party in establishing the violation of their rights should recover their costs, unless a strong justification can be pointed out for departing from that rule in their case. The state may not transfer the financial burden of remedying its own human rights breaches onto the individual. And that to remove the redress, the just satisfaction from the individual renders their right of access to a court theoretical or illusory rather than practical and effective in pursuit of their redress. The Zustovic and Croatia decision has one additional thing, I think, to add, which is the fact there that the court found not awarding costs in a judicial review didn't pursue a legitimate aim. That's paragraph 106, page 977. Sorry, tab 47.
Which paragraph was it?
106, please, my lord, page 977.
I suspect it's probably right to make this the last point before.
I've just noted the tab, thank you, lord.
Let's just look at it. Which was it? 106, did you say?
106, please, yes, page 977. So this is the absence of a legitimate aim where the claimant has succeeded in denying them costs.
Just before we go, Mr. Rule, how are you doing time-wise?
I indicated to my own friend, I appreciate we have tomorrow morning, I think, is the remainder of the hearing. I indicated to my own friend, my aim is to try and finish by 3 o'clock, and then we're on to the. I think I'm on course to do that. I know we've skipped forward slightly in my note and etc., but I think I'm on course to do that.
Very good. Well, we'll rise this again 2 o'clock.
Rise